Hello again. This is Ben Hitchcock Cross talking today. Um, let's see. The facts are that I have some Novak videos ready to go. Of course, I found an address of Sue Novak's in there, and I got to pixelate that out. And here we are with time. I had this idea in mind, so I thought I'd go through with it. Here, I am preparing for a couple of hearings today. Um, they are uh, like a municipal hearing where this is a alleging disorderly conduct of a client. This is one of those free speech disorderly conduct issues, so that's what we're going to talk about. And then I've got another one where it's just sort of a simple discharge, but at the same time, my goal here is to go in and cross-examine and to figure out a little bit more about what happened. So I'm being called in as a specialist to handle that, so that'll be fun, or at least interesting. We'll see what happens. I should never say fun, but certainly it will be an experience and an opportunity to excel. So, with that in mind, I just want to focus and share. We've got this page up here. I am talking about disorderly conduct. The issue, more or less, in my mind here is when is disorderly conduct? Wisconsin sort of has a famous disorderly conduct statute in that it was taken to the Supreme Court and saying, is it unconstitutional? What does it encompass? And really, disorderly conduct can really be anything. Almost, as we'll see. And so that then it becomes an issue of saying, is this protected speech or is this disorderly conduct? Sometimes it's both, and then we have to make the line of, to what extent it's not. So, got a couple of cases here. This is one way to do research, and this is sort of why I'm showing this out, how to look at these cases. And I used to be a very big advocate of especially the Google method to start out with, and I always think the Google method, at least for legal research, is a good way to double check your work. If you're working in Lexis or you have access to subscription-based services or other services, you're using legal research out of books from the local prison library, no problem. My point there is I found just simply Googling the question will oftentimes bring new information that I hadn't come across because it's a completely different search engine, but also new answers. So that's and feedback and demonstrating you're on the right page, because there's nothing like seeing a federal court complaint that has successfully been resolved. So for good feedback. All right. So if you can see here, I typed in Wisconsin disorderly conduct citation. That's just to distinguish it from the statute. I didn't necessarily want that, and I wanted to be clear that this is maybe a municipal citation as opposed to a circuit court thing here. That's sort of a lower level. Municipal court is going to be a lower level in Wisconsin than the circuit court. But here we are. So I see that we've got a little blurb from this Stengel Law Office. That's, of course, a perfectly normal spelling in Wisconsin here. And these guys do fine work as far as I'm concerned. I've used their blog several times. And so it says disorderly conduct is one of the most often crimes charged in the entire state because it really can encompass everything. 90 days in jail and $1,000 fine. I mean, that's a classic misdemeanor right there. How do you beat a disorder? I'd like to know. Freedom of speech. Ooh, involuntary actions. Self-defense. Hey, that's sort of where we were going. All right. So that's not the first place I would go, though. I'll just we're gonna go here, straight to the statutes. So, as you may be aware, most, let's say, governments in the United States, and I'm sure elsewhere, have rules that are written out. They codify their rules here. Let's see if that'll work. Bam. With that, so that the people who are subject to those rules can at least have the opportunity, at least in theory, to know what they are. And certainly if you're charged with the violation of those rules, you can go back and say, here we go. So what I'm reading here is whoever in a private or public place engages in violent, abusive, indecent, profane, boisterous, unreasonably loud, or otherwise disorderly conduct. Okay. So just starting with that, we've got public and a private place, so everywhere. I can't think of something as either public or private. So I don't even know why they have that in there. I mean, I know that they added the private thing later because of some case evolution in the 70s about whether sending threatening letters to somebody constituted disorderly conduct. It does. So pretty much whoever in any place engages in violent, abusive, indecent, profane, boisterous, unreasonably loud, or otherwise disorderly conduct. Here's what I want to explain about all of those is they are adjectives. I'm pretty sure if that's the word that I want. And so again, who's to say what violent, abusive, indecent, profane, boisterous, or unreasonably loud? I think that's a classic one. Who's to say again what unreasonably loud is? Well, so we're able to do that, and courts find that things are unreasonably loud all the time. It's not that a judge or a jury can't figure that out. Certainly, it's my question is that if I'm saying I can't do something that's profane, it's going to be kind of difficult to know what that is. So one way we can look at that is case law, and we're going to go see that there. Okay. So otherwise disorderly conduct, and then here's the big out here. It says under circumstances in which the conduct tends to cause or provoke a disturbance is guilty of a Class B misdemeanor. Okay. So that might, the disturbance concept there would sort of negate a theater. You know, somebody putting on being abusive, indecent, or profane, or even boisterous in a theater, right? I mean, where that's perfectly reasonable behavior. You know, what's unreasonably loud at a football game is not going to be what's unreasonably loud at a church or a courtroom or whatever else. So that's, I think, something to keep in mind in terms of what does that mean, okay? So, and I think a problem that many people have when they are trying to interpret what this means. Okay, I haven't been to law school. I'm looking at this document here. I know what indecent means to me. I know what profane means to me. That you may not have that same concept. So part of the way that we figure out what those words mean is that some poor schnook has come before us and been, you know, charged or convicted with disorderly conduct, and they have tried to get out of it in some way. You know, and I don't want to put it that there could be free speech crusaders. There could be all sorts of reasons, but ultimately, I think it's fair to say at some point they're trying to get out of the citation or whatever it is. Okay, so now here, and this is the official statutes from the official legislature. If you went and got the printed version, this is called the annotated statute. So somebody in the court's office has made the decision to add these annotations. They're not law, but there's no doubt that judges and sorry, let me be clear about that. What isn't law is the annotations themselves. That is the sentence that comes before the case. So we're looking here on this one, State versus Maker. Let me get that a little bit bigger, if that'll be helpful there. It says the defendant was properly convicted of disorderly conduct when he appeared on a stage wearing a minimum of clothing and intended to and succeeded in causing a loud reaction in the audience. Wow, 1970. I wonder if he was performing. I mean, there's a lot of questions about what I wonder. Okay, so there's going to be hyperlinks here that's going to take us to this case. Okay, we can do that here. I don't have time for this. Okay, to me, this would be a big sort of going down a rabbit hole that I don't need to take because my case does not involve somebody going up on stage. Wow. I just, though, red flag when I see the maintenance of order, liberty is basic objective of our constitutional form of government. Order and liberty are alike protected. Neither is to be extinguished in favor of the other. Order without liberty is tyranny. Liberty without order is anarchy. The constitutional mandate is that both excesses be avoided. I mean, in some ways, that's a indisputable statement. It's a very statist statement, and it certainly is. What would I say about that? I'm concerned about what's coming after that. Um, all right. So here again is this tension between, being allowed to appear with few clothes on and being boisterous on stage, and or not. So believe me, I'd like to know where this took place. When, I mean, we have a concept of the '68, somewhere around there. If the Supreme Court got it by the '70s, we're going to assume that those standard today has changed, but still. Okay. So, but that again is a rabbit hole. That's why I'm trying. You can see me resisting that. All right. This one I do find particularly interesting. An attorney was properly convicted under this section for refusing to leave a ward in a mental hospital until he had seen a client after having made statements in the presence of patients that caused some to be agitated. Okay? Again, that sentence right there is not the law. It's a description that somebody made who's, maybe an attorney or working for the Supreme Court, but is not the Supreme Court, is making about the case. Okay? So again, we see the defendant was properly convicted, and then we would have to look in here and see what exactly. All right, hey, here's the answers to our question. It was a tavern on the south side of Milwaukee known as the Bastille. The evening was a special occasion. The number of orchestras or musical groups appeared in sequence to entertain the audience. The defendant appeared as a musician member of an orchestra or musical group that was part of the evening's entertainment. Attire. The only attire of clothing worn by the defendant was a jockstrap or athletic supporter. As the complainant stated, he was wearing only a supporter of his private parts and paint on his body. One picture is certainly worth 1,000 words in describing the attire or lack of attire during the offended, but is enough here to state that the photographs establish he wore only a type of supporter or suspensory ordinarily worn under outer garments, usually under trunks in a gym. Holding as we do that the defendant's dressing as he did here constituted indecent and disorderly conduct within the statutory prohibition, did it tend to create or provoke a disturbance? Intent. The defendant testified that he appeared as he did to satirize the audience. Asked by his attorney, as a matter of fact, you were satirizing the so-called hippies and protesters that were there on the night in question. The defendant answered, that's right. As to the audience presence, the police officers testified these were supposedly hippies that were there at the time. Defense counsel argues that this may be established that you have an audience that's accustomed to the unusual. That may well be, but it is not an unreasonable inference from the testimony the defendant intended to seek and secure a definite reaction from the particular audience then present by dressing or undressing as he did. Reaction. Defendant's inferable expectation of securing an audience reaction was not disappointed. While the record is brief, almost sketchy, the crowd's reaction to the attire or conduct of the defendant was not of delayed response. It is not disputed, as the police officer testified. The spectators were all standing and looking at the stage. Some were standing on tables, yelling loudly. It might be reasonable inference that the scene described was little more than a counterpart of a Munich Brauhaus scene with high-energy young folks jumping up on beer-greasy tables to shine Prosit and showing approval or disapproval of the performer. However, it is as reasonable in the alternative report in a crowded tavern that there existed a shadow of mounting disorder, accumulating tension, and predictable explosiveness. This inference the trial court drew, finding that the defendant did in fact cause or provoke a disturbance. So that was a pretty awesome rabbit hole, and I'm glad we went down it. You can see the World War II anti-German fascist language, and I do think it's interesting how a court who's about to say that you can be put in jail for your your public disorderly conduct, and trying to compare what this guy is saying is free speech to him being a brown shirt. So I would I've got mixed feelings about that. Let's put it like that. But I'm sorry, and thank you very much for indulging me in this rabbit hole. I do appreciate it. Um, so now here is one that I read, and it says application of disorderly conduct statute to speech alone is permissible under appropriate circumstances when the speech is not an essential part of any exposition of ideas, when it is utterly devoid of social value, and when it can cause or provoke a disturbance. This disorderly conduct statute can be applicable. Well, that's sounds. I like this. I like the language of that. That sounds like a case that, although the guy lost, still there is some room for maneuver. So let's go there. And this is State versus AS. Like it. Bam. Let's go do it. State versus AS. All right. AS apparently is a youth, a minor. So we can't, we don't know their name, which is perfectly fair. There's obviously going to be enough information in here to get that. But all right. A juvenile seeks review of two determinations. Good for a juvenile. You know what I mean? The facts as pleaded in delinquency petition alleging disorderly conduct were sufficient to constitute probable cause. And two, that AS's statements were not protected speech under the First Amendment. This disorderly conduct charge was based on statements made by AS threatening violence towards a number of named individuals. Jeez. It's always... Let's put it another way. It's rarely the best defendants who go before the Supreme Court because, the best defendants don't have to. They already won. All right. And he argues that speech alone cannot constitute disorderly conduct. His speech is protected under the First Amendment, and under the facts of this case, elements of disorderly conduct were not met. Okay, we conclude that speech alone in certain contexts can constitute disorderly conduct. That context, AS's speech, is not protected by the First Amendment, and that the two elements of disorderly conduct are met here. Accordingly, we affirm. So the one that we're is his speech is not protected by the First Amendment. Okay. Disorderly conduct. Zwicker, yeah, we all know that one. So they're going to go over the law of disorderly conduct, okay? And then the sort of the intermeshing with disorderly conduct and free speech. Okay, that's going on here. We note that this limitation on speech is permissible because constitutionally protected rights, such as the freedom of speech and peaceful assembly, are not the be-end all. They are not absolute touchstones. Okay? Seems like sort of the same language at the beginning of the last case we read here. Here is the disorderly conduct statutes, which are not designed specifically to prescribe pure speech, may apply incidentally, limit speech in this manner, okay? All right, so if there's a clear and present danger of riot, disorder, interference with traffic of public streets, yikes, that's can't have that. And the other immediate threat to public safety, peace, and order appears, the power of state to prevent and publish is obvious. Okay, so, and then there's fighting words, fire, that's always one that's in there. Well, some classic stuff we're getting to here. Okay. Disorderly prescribes speech that is not constitutionally protected. It does not result in the statute becoming overly broad. Okay? That's the key thing here. How do we know that the speech is not constitutionally protected? Well, because if it is constitutionally protected, then it's not disorderly conduct. That's what they're saying. Fair enough. Because the constitutionally protected speech would trump this state disorderly conduct statute. Okay? But again, the state has the police powers, meaning the duty and right to enact rules and regulations for the state to for the maintenance, health, welfare, things like that, for those purposes. Those are police powers. Okay. So he can only be prosecuted if speech is one of the limited categories of speech that falls outside the protections of the First Amendment. That's a key thing to say. So he's saying it's speech. That's the key concept here of when he's saying is speech alone. Okay. Under appropriate circumstances. So he's saying, the court is saying, we conclude that the application of the disorderly conduct statute to speech alone is permissible under certain circumstances. And I would put that another way. It's saying we conclude that disorderly conduct statute applies to non-protected speech. I think that's fair to say. Okay? And then that's what the appropriate circumstances is. Now that is a statement of the law. That is the Wisconsin Supreme Court in 2001, paragraph 17 of the State versus AS case. We can cite to that. That is as good as a statute. Okay, you need to understand that fact categorically. In Wisconsin, maybe not in your state or your area, an appeals court statement, the same thing. We conclude that the application of disorderly conduct state to speech alone is permissible under appropriate circumstances. And if the appeals court wrote that, that would also be the law. Okay, so just keep that in mind. That is as good as a statute. And sometimes it's better because it's interpreting a statute. So now I think we know when we go back to this boisterous, profane, disorderly conduct, that's the big question there is are you engaging in protected free speech? Because if you are engaging in protected free speech, then disorderly conduct doesn't apply. Okay? When speech is not an essential part of any exposition of ideas, when it is utterly devoid of social value, and when it can cause or provoke a disturbance, the disorderly conduct statute can be applicable. Okay. Now I want to point out that seems like exactly what we read here. When speech is not essential, as a direct quote. Well, we didn't know that until we looked it up. And again, this sentence here is not the law. This sentence here, this paragraph here, is the law. Okay? Why? Because the Supreme Court, majority of the Supreme Court said it was. That's why. All right. Okay, so this is the third part. AS is saying his speech is protected. Okay? He said that immature trash talking is just hyperbole. All right, so it's not a true threat. I think that's where they're going at. So, all right. So, this case here is Brandenburg. This guy says it's Brandenburg. In that case, this guy says, if our president or Congress, our Supreme Court continues to support the white Caucasian race, as opposed to like the white African race, I don't know why they put that in there. It seems redundant, but I'll take their word for it. It's possible that there might have to be some revengeance taken. All right. So that, though, you can see how there's a political stem, President, Congress, Supreme Court, and then revengeance. It may not be the best way to put that, but again, there's advocacy. It's not mere advocacy to violence as long as it did not incite, imminent action. So let's go to the courthouse and go burn down the judge's chambers, for example. Please don't take that out of context. The point is here that is an immediate incitement to violence as opposed to there might have to be some vengeance taken. Okay? So now the state comes back and says these are true threats, and those are always recognized as unprotected speech. And we can go back here. There's going to be a sentence about true threats in here somewhere. Okay? True threats were not government to prove a true threat. Okay? The court reasoned that taking into consideration regarding the expressly conditional nature of the statements and the reaction to the list, we did not see how it could be interpreted otherwise. Okay, and that's, again, the threat is not just political hyperbole. That's like, we're going to come get you. Okay? True threat analysis. And there is here's a case that says where the true threat, and you need to know what true threat is. Then you go look to State v. Perkins, and we can go through there. Now, I'm going to stop reading from here because, again, I've gone down a rabbit hole, and there is a case that I really want to talk about, and almost read in its entirety because I think it's really famous. Here, this one is the one, State v. Schwebke. That's the case that says that if there's a real possibility of disturbance or disruption will spill over and disrupt the peace, order, or safety of the surrounding community, that can be disorderly conduct, even though it's private. So that's why it can be, disorderly conduct can happen anywhere. But this is, I thought, the one that would be most interesting to this channel. Here, defiance of a police officer's orders to move is itself disorderly conduct if the order is lawful. Brown versus Baldwin, okay? 2003. Now, I'm pretty sure that Baldwin is the sheriff of Milwaukee County at the time. And I can see here when it says 346F 3D 761 that this is not a Wisconsin case. This is actually a federal case. So this is the Seventh Circuit of Appeals, which includes Wisconsin. Somebody basically went to federal court, then they went the appeals court here, I think having lost both times on the question of could they be arrested outside of a courtroom filming let's say he was a protester in favor of jury nullification. And I remember him well. I having gone to the courthouse in that era, this gentleman would walk around the courtroom and courthouse handing anybody he could these handouts that said you can vote for jury nullification, and he would do so wearing a jester outfit. And as far as I know, I think he lost a case. I don't know what kind of case specifically, and I don't know even for sure that he lost the case. But as far as I understand, the justice that he received in the Milwaukee County Courthouse was not to his liking, and this is one of his responses, was to go around and telling everybody about jury nullification. Perfectly legitimate thing to do. However, they made a rule saying he couldn't go and tell jurors who were sworn jurors that about jury nullification during the time. So I think he did that. But that's not the issue here. Mr. Braun was videotaping the jester person, as we'll see, and the police officer told him to move along. He didn't move along and then got arrested. And what's even more amusing, I think, is that the jester guy continued to jest. So the question ultimately is if a police officer tells you to move along and you don't, and then he arrests you, is that a violation of your civil rights? Okay. Now these are Judge Bauer, Posner's a big heavy hitter, and Coffey. These are all pretty heavy hitters in the field of, in the Seventh Circuit justices or Seventh Circuit appeals court judges. And hey, so September 5th is Jury Rights Day in Milwaukee. On that day in 2000, Robert Brown, the plaintiff in this civil rights suit under 1983, and his companion in arms, William Whistleblower Courier, as was their custom on Jury Rights Day, entered the Milwaukee County Courthouse for the purpose of advocating jury nullification. That is, that jurors should feel free to disregard the instructions on the law that judges give them. They stationed themselves in the lobby of the courthouse. Courier was dressed in a judicial robe and carried a sign that said, "Why do judges hide the truth?" Okay, that refreshes my memory. He wears a jester's hat and a judicial robe. I remember him well. I was a paralegal for many years, and I would have to go back and forth to that courthouse or sit there waiting to file cases or all sorts of stuff. And he was a frequently present. Courier was dressed in a judicial robe and carried a sign that said, "Why do judges hide the truth?" The truth referred to apparently being that juries can acquit in criminal cases lawlessly. Whoa. All right. He handed persons entering the lobby who may have included witnesses and even jurors pamphlets advocating jury nullification. Braun stood by holding a camera, apparently to enable him to obtain evidence which might provide a basis for litigation of any attempt by courthouse personnel to expel the judge impersonating whistleblower. I mean, you can tell by the language here that these judges are no fan of Brown or Courier. But hey, it's their right to do that, so I don't see them saying that so far, but we'll see. But I also point out that I believe this is an actual camera, like camera, because of the year 2000. I'm going to guess it's 2000, certainly the turn of the century. So there probably wasn't so much digitalization in the cameras, but just a fun fact. All right. Apparently didn't obtain evidence which might provide the basis of litigation. Okay. So Brown and Courier are serial protesters and arrestees. They appear to be dedicated to the propagation of litigation. Courier versus Baldridge, 7th Circuit, 1990. Okay, so these guys already filed something 10 years ago. They made it all the way up to the 7th Circuit, and apparently that didn't go that far. I don't know where that quote comes from. I assume that's from the judge in there. I just want to point out that if you would look at, AT&T's filings, for example, or Wisconsin Electric Power Company or City of Milwaukee, you might say that the City of Milwaukee appears to be dedicated to the propagation of litigation. I mean, you might just doing the numbers here. So I haven't read Courier versus Baldridge. I'm clearly judging a book by its cover, but just by doing the numbers here, it always sort of seems strange to me that a single person, as compared to a corporation, for example, would be such a serial litigator. But hey, a sheriff's deputy named Frank Frykoniak, the only defendant who belongs in the case, the other two defendants, the sheriff himself and Milwaukee County, have no possible legal liability for the conduct about which Braun is complaining. Wow. There is some shade being thrown in this by this author. Observing but doing nothing to impede Courier's antics, noticed that Braun, standing at a distance from Courier, was taking pictures of the officer. Frykoniak was on the alert for trouble because someone had phoned the police that there was a disturbance taking place in the courthouse, and he had been told about the call. When he approached Braun and asked him what his business in the courthouse was, Braun refused to answer and instead threatened to sue Frykoniak, who in response asked Braun to step aside. Braun admits this while also claiming that Frykoniak told him to leave the building altogether. When Braun refused, Frykoniak arrested him for disorderly conduct. No charges were filed, nor was Braun jailed. He was merely expelled from the courthouse, though later permitted to return. But the arrest precipitated this civil rights suit for infringement of freedom of speech and for false arrest. Braun's threat to sue had not been an idle one. I mean, come on. That seems a little over the top, in my opinion. I've got two minds on that. And I know Judge Paz, I know that I've read many decisions from these judges, and I know that they generally have this reaction, and I get the institutional reaction to this kind of litigation. At the same time, I think that it's putting this kind of institutional bias in the writing, in my opinion, doesn't deter I won't think that it's going to have the effect. I don't think that Braun and Courier, having read this shade, will have altered their behavior. But I don't know. But as there is no indication that his arrest was effectuated in an unusual and proper manner, the excessive force claim has no possible merit. The district court granted summary judgments for the defendants on all accounts. Okay, again, summary judgment. They had discovery. They one side went to the court, I assume the county, and said, you've got to throw out all this entire suit because they don't have, there's nothing they can bring that a jury could possibly award to them because the facts of the law are completely against them. Okay. We addressed the free speech issue first, which is all what we care about. Here, when Frykoniak arrested Braun, he may not even have known that Braun was present to assist Courier in advocating jury nullification. In that event, even if the arrest had been improper, the second issue that we consider, it could not have been intended to curtail Brown's freedom of speech. Okay? Because he didn't know that he was advocating for free speech, therefore he couldn't have been curtailing the speech, I think is the logic there. For that matter, we don't know whether Brown had any intention of speaking or pamphleting or otherwise exercising a claimed right of free speech, so we don't know whether there was even an unintentional interference with his freedom of speech. Currier was not intimidated by Brown's arrest and continued handing out pamphlets in the courthouse lobby without interference. Okay, so that I there is some unpacking that needs to be done there, but I think it's important. If, for example, that was you wanted to go emulate these people here, Brown's problem was it may have been that it wasn't obvious that just because he was taking a picture that he was engaged in some kind of political activity as opposed to disorderly conduct. Okay? Now, I'm suspicious of my own that taking pictures could tend to provoke a disturbance, but I get it. I can see why a judge might think that. I also think that one of the mistakes that Braun, or let's say we could have had a different fact situation if Braun had answered the officer's questions and said, I'm here assisting this for jury nullification day or something along those lines. That would have alerted and defeated this argument here that Frank Kowiak was not aware that he was engaging in free speech. Now it says there's a deeper problem. Free speech rights are absolute. So even if he did know he was engaging in free speech, there could have been a problem with that. So even if he had known, it would be unconstitutional for the states or federal government to provide a legal remedy for defamation, to punish the possession of distribution of child pornography, or to forbid the publication of military secrets. And it's sort of extreme, but okay. To ever conduct legal proceedings in camera, that means without cameras, really. It means in room. Or coming closer to home, to prevent Currier and Braun from handing their pamphlets advocating jury nullification to jurors sitting in the jury box. Although advocating of jury nullification could no more be flatly forbidden than advocating Marxism, nudism, or Satanism, we cannot think of a more reasonable regulation of time, place, and manner of speech than to forbid its advocacy in a courthouse. Okay, that's something you got to unpack there too, is saying that for a restriction on speech to be reasonable, it has to be reasonable time, place, and manner restrictions. Okay, so this speech that may be inappropriate at 3 o'clock in the morning may be appropriate at 3 o'clock in the afternoon. Okay, speech that may be inappropriate at in a courtroom may be appropriate outside of the courthouse. Speech that may be appropriate in terms of tone or volume may not be appropriate if it's too loud. Okay, so governments can place rules on the time, place, and manner of speech, but they still need to be reasonable. Okay, so it wouldn't be reasonable to say you can only have free speech for 5 minutes from 3 to 3:05 because there's no reason for that. Okay? A state may adopt safeguards necessary and appropriate to ensure that the administration of justice at all stages is free from outside control and influence. Okay, and this is going back to we don't want these guys messing with the jurors while cases are going on. And here's a case from 98, and there's a kinetic statue. I don't know what that is, but it sounds like a robot, a kind of robotic version of the whistleblower courier. The lobby of the courthouse is not a traditional public forum or designated public forum, not a place open to the public for the presentation of views. Courts seek to induce the jurors, the witnesses, and the litigants who pass through the lobby on the way to the courtroom a serious cast of mind. The judiciary does not show reruns of the Three Stooges in the courthouse lobbies, and from the perspective of promoting the judicial mission of sculpture satirizing judges would be worse than old physical comedies. No one doubts that displays in courtrooms and adjacent corridors may be limited to the icons of government, such as seals, flags, and that judges may insist that all those present behave in a dignified manner. Why should this be less true in the lobby? Newspapers and the streets outside are open to scathing criticism of what happens within the courthouse, but the halls of justice may be kept hushed. Okay. So that's a place restriction. All right, and so now we go on to jury nullification and so forth. I'm going to wrap it up here, but wow, I'm going to finish with just reading this phrase here. The biggest surprise in this case is that Milwaukee justice system tolerates Courier's antics aided and abetted by Braun. If it thinks that the First Amendment requires this, it is mistaken. Selfick makes that clear, and see United States versus Ogle, rejecting the challenge based on First Amendment to a conviction for obstruction of justice for giving a juror a pamphlet advocating jury nullification. That's saying if you guys were allowing this to happen, you, Milwaukee County, were allowing these guys to happen because you were afraid that we were going to tell you, no, have at it. Have at it, guys. That's what that's saying there. So, that is a take on the First Amendment. I think it's a little sort of brief introduction to some core concept of time, place, and manner restrictions. I think we've got some good work here on what is disorderly conduct, and I think it's kind of in the eye of the beholder. That's what I got out of that today. And it's kind of challenging to defend because it's such an all-encompassing and wiggly statute, and who's to say that your behavior was not boisterous? Who's to say it wasn't profane? You know what I mean? So stick with us. We'll keep you informed.